10 tips for winning in the courtroom coming up right after this.
Yes.
Hey everyone, welcome back to the Mr. Small Claims Court YouTube channel, or welcome if this is your first time checking out one of my videos. Grateful to have you. I'm Jordan Farkas, and for those who have seen my videos or who have subscribed, you'll know what my credentials are. If you're just coming to this video for the first time coming to my channel, then if you go to the video on the homepage, you'll learn a bit more about me. And if you hit that subscribe button and that notification bell, you won't miss a future video, which will be helpful, especially if you do find yourself with a small claims court lawsuit or potential lawsuit. Of course, it does help me as well to continue producing videos just like this. Now, with all that said, today's video is about 10 tips that I'm going to give you to help you win in the courtroom. Now, what do I mean by that? Well, I've talked a lot in my earlier videos about small claims court strategy, which has to do with preparing your claim and providing a copy to the defendant, preparing your evidence, what your evidence should look like, how to prepare strong evidence. And by the way, there's much more to discuss, which I'll do in future videos, but that's a bit of a synopsis of some of the videos I've done. This video is more about you, what you can expect or maybe not expect, as I'll get into soon, when you get to the courtroom. And there's a way in which you can carry yourself in order to put yourself in the best position possible to win. And that's what the intention of this channel is, really, for you to win in small claims court. And the intention of this video is to give you those 10 tips that I feel will help you win your lawsuit based on how you conduct yourself at the trial. So I've got my usual, for those who have seen previous videos, very old school whiteboard over here. Still waiting to get more adept at my video editing. But for now, hopefully you'll find the whiteboard to be effective and a little bit more interesting than just looking at my pretty face. As I've joked before in earlier videos, it gives you something else to look at as you're watching this video. And the first tip that I'm giving you actually starts before you even get to the courtroom, and that is to meditate and visualize winning. Now, I know what many of you may be thinking, especially if you're not into the heebie-jeebie, if you will, or any of the spiritual stuff or New Ageism, however you want to refer to it. I happen to very much enjoy these types of concepts, and I read a lot about various spiritual practices, which includes meditating. But even if you are not the type, what I would say to you is maybe suspend your cynicism and try it, because what you're trying to do is win. So if somebody is giving you a tip, as I am over here, that says that this can actually help you win, then why not give it a shot? What do you have to lose? Nobody has to know about it. You do it in the privacy of your own home or your car. It doesn't mean you have to sit there like a guru or a monk or anything like that. Meditating just means taking a couple of minutes to calm your mind, just do a little bit of breathing. And visualizing is really visualizing success, visualizing the outcome, even if you're not great at visualizing. I happen to not be the best visualizer. Okay, that's a whole other video I can do on meditation and the different types of meditation. But visualizing as best as you can, that's the most important thing. Just making your best effort to visualize going to court and winning. That will very much help you once you get to the courtroom. It will relax you, it will calm you down, and it will put you in a much better state of mind for when you actually walk into the courtroom to prepare and to ultimately have your lawsuit. And I can tell you from experience that when I was able to take the time beforehand to meditate and visualize success, it actually made me successful. Okay, now I can't say that that's the only factor. Of course, the things I talked about in earlier videos and we'll talk about in future videos also help you maximize success. But this is one more tool in your arsenal, if you will, that will help you be successful. Now, really, I would suggest doing this from even a few weeks before your actual trial, not just waiting for the day of or the day before, because the more you do it, the more you can sort of plant that into your subconscious idea that you're going to be successful and actually manifest that. Okay? But for those, again, who maybe are a little bit more inclined not to be into this sort of idea of meditating and whatnot, then in the very least, I would suggest try doing it on the day of trial, because if nothing more, it acts as a sort of relaxation technique. And it's very crucial to go into that courtroom as relaxed as you can. I definitely understand that it can be stressful. It can be tense, especially if it's your first time in a courtroom and hopefully your last time. But in any case, this will help put you in that right frame of mind. So I suggest that you suspend your disbelief, suspend your cynicism, give it a shot, do as much as you can before your trial, but in the very least, do it on the day of trial to help get you into that relaxed state of mind. So that's tip one, is to meditate and visualize. I know that's not something you'd commonly hear from an attorney or retired attorney as I am, but I'm not the conventional attorney, in case you haven't noticed already. Tip number two, I should say, is to dress appropriately. Okay, I know my handwriting is a bit small, it's hard to read, but that's what it says there. Dress appropriately. Now, I purposely use the term appropriately because what does that mean to dress appropriately? Well, it really depends on who you are. So if, for example, your lawsuit is based on you being a high-powered executive who didn't get paid a certain bonus or something that was owed to you, but it still falls within the jurisdiction of small claims court, then maybe you want to put on that suit and show that you're an actual executive. You don't want to say that you're a successful executive who didn't get paid and show up in overalls. On the other hand, speaking of overalls, if you're a farmer, for example, and somebody didn't pay you for something you produced on your farm that you were supposed to be paid on, then I believe, and not every attorney will agree with me, some attorneys will argue that everybody should show up in a suit. I believe that you should actually dress respectful of the court. So that may not mean overalls. That may mean just a regular button-down shirt and jeans, but a button-down shirt and jeans can be a good way of really demonstrating who you are in an authentic manner. Okay, so you're showing respect for the court in the way that you know how, while at the same time not being over the top. Once again, some attorneys may disagree with me, but in my experience, those who are respectful of the court so that they put on a bit extra to dress up for the court, and it's clear that they're dressing up for the court, but don't necessarily go over the top to pretend to be somebody that they're not, I find that to be the most effective attire. Okay, certainly you shouldn't be going in there with your shirt untucked or, in any sort of inappropriate manner of dress that would signify to a judge that you don't take this seriously. The judge wants to know that you take this seriously. The judge shows up, depending on the court, in a gown, in a robe, or maybe in just a suit. Every court around the world will have its own procedures, but in most courts, I would say it's fair to say that the judge dresses up for the occasion in ways that judges do, and they expect the same of the people that are coming to court, once again, realizing that that doesn't mean that the average person has to necessarily wear a suit unless the rules of the court call for it. So you should check, as I always suggest, check the website of the small claims court jurisdiction where your lawsuit is to see if there are any sort of rules about dress code. But assuming there's no specific rules about dressing, then dress respectfully, but also dress appropriate to what you're claiming, appropriate to who you are or what your profession is in the context of your lawsuit. So that's tip number two, to dress appropriately. Tip number three is to arrive early. Okay, now why do I say arrive early versus arrive on time? Well, because if you aim to arrive on time, oftentimes there will be things beyond your control, like traffic, for example, to take the most common situation where something will stop you from being on time. And before you know it, you've arrived late. And I've actually had cases where somebody arrives just even 15 minutes late and the judge dismisses their case. Believe it or not, it's happened. It actually happened. I'm embarrassed to say, although maybe I shouldn't. It's part of the learning experience. It happened to me when I was a young law student and I had shown up late to court. It wasn't a trial. It was a certain procedure. The judge dismissed it because I wasn't on time. To this day, I think that was unusually harsh, by the way. But in any case, the judge did. There was an older, craggy, not a very fun-loving judge, let's just say. And I was trying to beg the judge to keep the case on the docket, on the court file list, and he refused. We were able to get it brought back into the court system by simply bringing what's known as a motion. A motion is kind of like an intermediate step that you can take to make a request of a judge to do something. But it was very embarrassing to have to explain that to the client, to have to bring that motion at my own expense and get that matter back heard on the trial list, on the court docket. So I definitely suggest that you aim to arrive early, because if nothing more, at least hopefully you have given yourself enough time that even if you're not early, ultimately you at least arrive on time, which is super crucial so that you don't have any sort of issue or your case dismissed or any other thing that can happen against you as a result of arriving late. Also, the reason why I say arrive early is because it is good to arrive early, because as I mentioned earlier, for many of you that are watching this video, it will be your first time ever in a courtroom or perhaps ever in a small claims court. In any case, it can surprisingly be overwhelming, okay? A lot of times what sounds fine conceptually, okay, I'm going to go to small claims court, it's my lawsuit. You walk into court and it's like, whoa, like, depending on which court. I know in Ontario, Canada, where I'm from originally, it's very formal looking. It's an actual courtroom. In other jurisdictions, maybe it's in a less formal setting. But either way, it's that feeling of knowing that there's a lawsuit that's going to be decided here. It's a court of law. That can be very overwhelming. So when you arrive early, you give yourself a chance to get acclimated to your new surroundings and your new environment. And that, as I mentioned from the outset, it's very important to be relaxed and as calm as you can. So therefore, by coming earlier, you give yourself that chance to kind of calm down, find your bearings, stay centered, and be that much more in a better position to deliver your lawsuit at the trial in a much more efficient and relaxed manner. So definitely strive to arrive early. Tip number 4, I've entitled, fake it till you make it. Now, what do I mean by fake it till you make it? Well, I was going to write there, be civil with the defendant being the person who you're suing. Okay, obviously, if you're a defendant watching this, then the plaintiff is your opponent and you are the one who has been sued. A lot of these videos up until now have been from the standpoint of a plaintiff, the one who's suing, but definitely I will be doing videos from the standpoint of a defendant. Still, if you find that you're a defendant watching this, there's a lot you can learn from the tips that I'm giving for a plaintiff. A lot of them work in tandem with one and another. Doesn't matter if you're a plaintiff or defendant. Some of them will be more geared towards one or the other. But the point is that let's say in this case, you are the plaintiff who sued the defendant and you see the defendant sitting just a few feet from you. It's very easy to get lost in your emotions and get tempted to start cursing and cussing at the defendant or yelling at them and getting very emotional. And there's, I would say, very little, if not nothing, that judges hate more than parties who cannot stay in control of their emotions and who are just acting up in court and being obnoxious or rude to the other party, definitely being rude or obnoxious to the judge, which is a huge no-no. I talked about that in the earlier video, but certainly also being rude and obnoxious or angry or emotional with the defendant who's sitting a few feet across from you. The judge expects you to have decorum, to maintain your composure, and I cannot stress enough that you must be civil throughout the trial. Even though the defendant is going to say things that annoy the heck out of you, he or she is going to say things that you feel are outright lies. Whatever the case is, yes, it is very likely that somebody who has not paid you for as long as he or she has is going to tick you off. And your goal is to remain as calm as you can, as unemotional as you can. And by watching this video and making a note of it now to tell yourself, I am not going to let myself be emotional, you're in that much more of a better position not to do that at the trial. And judges will notice that and they'll appreciate that, especially if the other side has not watched this video and they're acting all emotional and abusive and obnoxious and getting angry, etc. You're in that much more of a better state and a better place to win than the other party. That said, sometimes, and this again will be the subject of a future video, I know I keep repeating that because there is so much to talk about when it comes to small claims court, believe it or not, there's a ton. That's why I have this channel. Sometimes you can strategically kind of give a look of displeasure when the defendant says something, let's say, that's patently untrue. But you don't have to do it by screaming out in court. You should not do it by screaming out in court or anything like that. But sometimes the judges will look at the parties. So maybe you want to kind of signify to the judge in a very discreet way that you disagree with what the defendant is saying. So maybe you'll just kind of like slowly like nod your head like that. That's okay. You haven't acted out. You haven't screamed or yelled. You're just kind of showing a bit of disapproval. It's kind of a fine line though, because if you do that too much, you may fall under that slippery slope, as they call it, of getting angry and acting out in the courtroom and getting all emotional. So you got to be careful. But to do it kind of passively in a very subtle way, but one in which maybe the judge could pick up on, that could help you. So I'm not suggesting you don't have to show any emotion, but the key is to really keep, quote unquote, those emotions in check, as I talked about in the last video, or let go of those emotions when you're sitting in the courtroom, because that's going to put you in a much better position to win your lawsuit. Okay. Tip number 5 is to address the judge only. Now, this is a very common mistake. People get into court and they see their opponent next to them and their opponent says something to the judge, and then the other party starts arguing with that opponent, right? So let's say, John has sued Sally and Sally is talking to the judge. And as far as John's concerned, Sally is just saying outright lies. So I can't tell you how many times I've seen John start yelling at Sally, that's not true, I didn't say that, I never did that. And he starts bickering. This is kind of similar to what I said before about keeping your emotions in check. but it's a bit different because what I'm saying here is that you should always be mindful that the judge is the decision maker. Keep your eyes on the prize, so to speak. The judge is the decision maker, not Sally. So whatever Sally says, you have your chance to rebut that, to address that, but address it to the judge. You say, Your Honor, when it's your turn, obviously, when the judge calls you, Your Honor, what Sally is saying is simply not true because such and such and such. But when you start bickering with Sally, the judge just gets really annoyed because the court is not about a bickering match. Now, if the judge specifically directs you to interact with Sally, or let's say Sally starts bickering with you and the judge is allowing it to happen, then maybe what you would do then is say, Your Honor, should I respond to Sally or can I respond to court? And the judge will direct you what he or she wants you to do. Okay, so it's always an effective strategy to make sure you're addressing only the judge, not the other party, because it's the judge who's the decision maker. The judge is the king of the court, so to speak, and the judge is the person who you want to make sure that you're following in terms of instructions and orders and anything like that. So always address the judge. Tip number 6 that I have written here is keep it simple. Okay, now I've spoken about this before, but it's still worth repeating that when you're presenting to the judge, and I'll get into this more specific strategies that has to do with cross-examination and direct examination, the types of questions you're asking your witnesses. That's not for this video. This video is more about general decorum at the lawsuit. But when you are presenting your case, make sure to remember to keep everything simple for the judge. Don't get into very complex arguments. Don't try to speak overly academic, unless maybe you're a professor and your lawsuit has to do with something professorial. There's a professor word right there. But generally, you should keep things simple. Don't get overly, what's the word I'm looking for? Overly complex. I was looking for a different word. I can't find it right now. Speaking of simple, so I should follow what I'm saying about keeping it simple. Make sure you speak in layperson's terms to lay it out very simply for the judge, not try to get overly complex. Don't try and pretend like you're a lawyer if you're not. Just keep things simple for the judge. I don't have to get into that any more than that. Keep it simple can be said simply. All right, so there's no need to get into that anymore. And I've also talked about it in earlier videos. The next tip I have on my list here, this is tip number 7, is to pay attention to your opponent. Okay, so I said before that you shouldn't be communicating with your opponent directly, and that's true, but you should certainly pay attention to what they're saying. I would suggest taking notes if you can. If taking notes is going to distract you from actually paying attention to what your opponent says, then listen very intently. Either way, you should be paying very close attention. Why is that? Well, for a number of reasons. Number one, when your opponent says something in court, you're going to want to cross-examine him or her on something that was said. And if you're not listening to everything that was said, you're not going to be able to cross-examine your opponent. By the way, this applies to the opponent's witnesses too. So the defendant will have witnesses possibly at the trial. Anything that the defendant or that the defendant's witnesses are saying, you want to pay close attention so that you know what to address to the judge in rebuttal, what to address to the defendant himself or herself if you're asking questions under oath, known as a cross-examination of the defendant, or if you're cross-examining the defendant's witnesses. The only way you can do that effectively and most effectively is by paying very close attention. Again, I've seen so many times the mistake where parties show up in court, and we're talking about, let's say, plaintiffs here, and they're so enwrapped in their own case, they're not giving any attention to anything that the defendant says. And that's a big loss because instead of having an opportunity to really rebut something that the defendant says, instead you're wrapped up in your own case, you're not paying attention, and you've lost a crucial ability to poke a hole in the defendant's case. And that's what you're trying to do here. You're not only trying to present your case in the strongest possible way, but also rebut the defendant's case to disprove what the defendant is trying to say. And you can only do that by paying very close attention to what the defendant's saying. So when it's your turn to talk, by all means talk. But when it's the defendant's turn to talk or the defendant's witness's turn to talk, by all means listen. Listen very intently so that you can best disprove what they're saying when it's your turn to talk again. Tip number 8 I have listed over here is to speak slowly and calmly. Now, some of you watching this video may think, well, Jordan himself doesn't speak that slowly and calmly. And guilty as charged, sometimes I run afoul of, following my own advice when it comes to my videos. I definitely could learn from a lot of my own tips. But the point is that I'm not sitting in a courtroom now as we speak. I'm sitting in front of a webcam talking to you, to my audience, being very grateful that you're watching this video. But when you're actually sitting or standing in a courtroom and you're speaking to the judge, you want to make sure that you're speaking slowly and that you're calm and that you're presenting your case in a way that the judge can understand it. Because remember, the judge is most likely are hearing lots and lots and lots of cases on any given day or any week or any month, whatever the court system looks like in your jurisdiction. And the best way that they can actually absorb the information you're providing, okay, is by you speaking slowly so that the judge can actually listen. And a lot of judges like to take notes. If you're going too fast, yes, some judges will slow you down and ask you to speak slower, but a lot of judges will say to themselves, well, okay, if this is the way he wants to speak, fine, it's going to be what it's going to be, and I'll catch what I catch. Judges are human, and some judges do think like that. I'm not saying every judge does, but some judges do. By the way, the other reason I could speak a little faster is because, let's face it, a lot of people's attention spans these days online is not what it is in person. And also, you can always pause this video, which I recommend that maybe you want to take notes on what I'm saying. So in any case, I digress. But the point is that I'm talking to you, the audience, who has a lawsuit in a courtroom. You definitely want to speak slowly so that the judge is not missing anything that you have to say, and that the judge can best understand what it is you have to say. Tip number 9 I have written down here is expect the unexpected. Okay, expect the unexpected. A lot of these are cliche, expect the unexpected, keep it simple. Okay, you know what? A lot of times they're cliche because they earned the title of being cliche, and there's a reason for that. And in small claims court lawsuits as well, why do I say expect unexpected? Because really anything can happen. I've said that time and again, and I will continue to say that because it's so important to know that about small claims court. Anything can happen. I've heard lawyers call it the Wild West, so to speak. Anything can happen in small claims court. I'll give you an example. When I think it was my first trial ever as a young lawyer in small claims court. And what's supposed to happen, at least in the jurisdiction where I was in Ontario, Canada, the plaintiff presents his case first, followed by the defendant. Right off the bat, the judge walks in and he says, all right, we're going to hear from the defendant first. I was like, what? I was totally not expecting that. And I had to adjust very quickly. Now, fortunately, I was able to do that, having the training that I had and the preparation that I did, the things that I'm going to talk about or I have talked about with you in earlier videos and in future videos. And that always helps. That's why preparation and watching videos like this to better inform yourself before you go to court is so important. But at the time, I was really surprised by that, and it threw me off for a little bit, although I was able to pivot and be okay with it. But for the average layperson who's not an attorney like I am and like I was, a retired attorney, then that may be something that's very difficult for you to really adjust to. So if you go into the trial at the courtroom expecting the unexpected, knowing that something that you totally did not anticipate or did not expect can happen, you'll be in a much better position to address that. And other examples could be, for example, which I've talked about in earlier videos, let's say the defendant shows up with an email as evidence that they want to rely upon that you've never before seen in your life. So that can really throw you for a loop. Hey, what's going on? How come I'm seeing evidence for the first time? Now, you may be in a jurisdiction, I believe the New York Small Claims Court, for example, is a jurisdiction where you just show up with your evidence on the day of trial. So that could be, it could be that the defendant doesn't have to provide you with the evidence that they're relying upon before trial. This is just an example. Or the defendant, for example, shows up with witnesses who you didn't expect, long lost cousins who you didn't know have any sort of knowledge of what happened in the case. Whatever it is, anything can happen when you get to a trial. You could often be taken by surprise. And the point is to go in there knowing that this could happen so that you can deal with it. So what would be an example of how you can deal with something? So let's say in the example of evidence, let's say you're in a jurisdiction where the defendant did have to provide that to you before. So if you stay calm and know and say to yourself when this happens, all right, Jordan said in this video to expect the unexpected. The unexpected just happened. What do I do now? You could take a few seconds and kind of calm yourself. And then you can do something like ask the judge for an adjournment. You say to the judge, hey, I didn't know that the defendant was going to be relying on this. I have some evidence of my own that I think can address this, that I would like to use to rebut this piece of evidence that the defendant is relying on. Can I have the trial rescheduled for a later date? The judge may or may not grant your request. That's besides the point for this example. The point is that by expecting the unexpected, you were able to be a little bit more calm versus if you had never seen this video and you show up to trial and the defendant does something that you never thought was possible and just freak out and flip out. Okay, so expect the unexpected so that you could be in a better position to handle surprises that come your way and most effectively deal with them. And finally, the last tip I wrote down here is to apply all of the above tips to witnesses. Okay, so things I talked about in terms of dressing well and keeping things simple and addressing the judge only and all the sort of things I talked about. I'm just looking at my list here, arriving early, everything that I talked about before, the previous 9 tips, you should go over this with your witnesses, okay? Because if your witnesses show up late, there's a risk that the judge may not be willing to hear that witness. And that's an extreme example, but it could happen. Or maybe you want to ensure that the witness dresses appropriately for court. You may want to talk about the witness keeping things simple and not overly complicating the language that they use. Any sort of tip that I gave you before, these are things that you can also apply to your witnesses. So if you do have witnesses that are going to be testifying for you at the trial, make sure to brief the witnesses on what I'm sharing in this video in terms of my 10 tips. And you may actually want to forward this video to your witnesses to make sure they have a quick look at it before they get to court. Okay, now obviously you should be rehearsing with the witness to make sure they know the types of questions you're going to be asking them. That will be the subject of another video to make sure that you and your witnesses are on the same page. But as far as the tips that I'm giving in general for courtroom decorum and arriving at court and things of that nature, it definitely makes sense to go over this list that I just went through in this video to make sure that your witnesses also know to apply a lot of these tips to themselves as well. So just to do a brief recap summary of the top 10 tips to help you win at the courtroom. Number 1 is to meditate and visualize. The earlier before your trial you can do this, the better. In the very least, try and do it the morning of your trial. Number 2 is to dress appropriately. Remember, I strategically chose the term appropriately. It will depend on who you are and what your lawsuit is about. Number 3 is to arrive early. Number 4 is to fake it till you make it. In other words, be civil with your opponent. Number 5 is to address the judge only. Number 6 is to keep it simple. Number 7 is to pay attention to your opponent. Number 8 is to speak slowly and calmly. Number 9 is to expect the unexpected. And number 10 is to apply all the above, lather, rinse, repeat, to the witnesses who will be testifying for you at the trial. I hope you found that video helpful. As always, if you have anything you'd like to add, any comments or feedback, feel free to leave that in the comment section below. If you have something you'd like me to address in a future video, I may just do that. If you leave that in the comments below, it won't be specific legal advice for your case, but if I find that it's a topic that comes up a lot and that my audience can benefit from, I would be happy to do that. All feedback is always welcome. Once again, if you've already subscribed, I really appreciate you doing that. It helps me continue doing videos just like this to help you win in small claims court. If you haven't subscribed and you are dealing with a small claims court lawsuit, or you may have one in the future, I would encourage you and thank you for subscribing. It takes a second, and hitting the notification bell so you don't miss a future video. And once again, as always, I thank you for visiting. And until next time, I'm looking forward to seeing you at the next video. Hey, thanks for watching. If you found that video helpful for winning your small claims court lawsuit, then you're not going to want to miss a future video. Hit the like button, the subscribe button, and the notification bell. It takes a second so that you don't miss a future video to help you win your small claims court lawsuit.